All right, good morning and welcome to the House Environment and Energy Committee. This morning, we are going to be continuing testimony on H687, an act relating to community resilience and biodiversity protection through land use. And we are going to hear first from Tim Taylor, who's joining us by Zoom. Welcome back, Mr. Taylor.
Thank you for having me back. So just for I'm very happy to be here today. I'm very sorry I'm here by Zoom, not only weather-wise, but strep-wise of all things. Can you imagine 72-year-old man with strep? But I guess that's been going around. Anyhow, for those of you who don't remember me or don't know me, I'm Tim Taylor, and I'm a retired vegetable farmer. My wife and I started Crossroad Farm 43 years ago here in Post Mills in the town of Thedford. And we recently sold it to a former partner and a young man who's actually only 37 years old. So we're very excited about that. And then additionally, for 12 years, I was chair of the District 3 Environmental Commission, which comprises many towns in Windsor County, Orange County, and believe it or not, two little towns in Addison County, Granville and Hancock. Population-wise, it varies from almost 11,000 in Hartford to about 300 in Granville. And I've served on the town DRB Development Review Board in Thedford for 20 years, and most recently for the last 5 or 10 as chair. And finally, I actually went to Vermont Law School and graduated in 1978. Also failed the bar twice, but I did pass in New Hampshire. I'm proud of that fact. So it's nice to laugh a little at these things, I think. I worked for Jonathan Brownell. I clerked for him, and he was one of the drafters of Act 250. And the farm largely exists because of Act 250, but that's a story for another day. So I'm extremely, extremely excited to be here because so many times I've made an appearance, it's been to criticize something and to be upset about something. And this piece of legislation as drafted is just magnificent, I think. Now, I'm not any expert, as you can tell, but I think Chair Sheldon and Representative Bongartz and any others who participate in this have done a wonderful job of balancing the need for exemption in our planned growth areas and a robust review and scrutiny in critical resource areas. So I'm a big fan, and I hope the Senate gets on board and seriously looks at this. I think there's, really two foundation blocks of this piece of legislation, and one of them is planning, and planning has been something that has been missing, as I think you all know, from Act 250, from almost its inception. And I think with planning, we actually could see a reduction in cases that are contested, and that's perhaps because a picture being 1,000 words, an applicant will go on a map, see where the proposed development will be, and hopefully we'll have some clearer idea of what exactly is expected to occur in that area. So many times as chair, and we issued over 400 permits in that period of time, and so many times I can't tell you how frustrated we would be. I wanted to mention, by the way, anytime you want to interrupt me, because it'd be cool if this was kind of a dialogue, but we would get frustrated so often because we go, if they only planned this out a little more and thought a little more about it, we wouldn't be here. So I'm very excited about that building block. And the other part of the building block, I think, and foundation is this enhanced or new professional board, the ERB, the Environmental Review Board. Its principal roles would be reviewing, legislating, and supporting. Legislating, I guess, would be more called rulemaking. But I think these are the foundation blocks of this piece of legislation, and going forward to a robust revival and new Act 250. Without them, I think without these anchors, I think things will fail and not work too well. I like to call this location resource-based jurisdiction, primarily because what you're doing for the first time is taking a piece of land and seeing where it's located, and then examining what the resources it possesses. And that's very exciting to me. We're doing that in our own town in our own way now with some mapping and that kind of thing. So getting into the weeds a little bit, the definitions of that you have of connecting habitat, forest block, fragmentation, habitat, critical resource area, rural working lands, and clear, I think are very clear and succinct. In fact, if I were chairing a hearing, and involved in that issue, 8A issue, I think I would be able to understand from the way that it's presently drafted what was expected of us to do and look at. I think it directs us. The only question I really have is this mitigation question referencing 6094. I couldn't find that anywhere in the statutes. I found 6093, which has to do with mitigation of prime agricultural soils, but it follows sort of a similar step-by-step process that we would use with prime agricultural soils as well. Let's see. Resource mapping. I think that, again, a picture is worth 1,000 words. I think that's excellent and very needed, and excited to see that. I wanted to make an old plea for something that's very near and dear to my heart, which is, and I know it's somewhat beyond the scope of this, but I think it's time to mandate towns without zoning and subdivision regulations to acquire them, and give them a date certain to promulgate them. I will remind you all that 47% of the towns, or 125 towns, do not have planning and subdivision regulations. And wouldn't it be wonderful if we stopped having to make this 10-acre, 1-acre distinction, and just all towns were in the same boat when we start off? So that's just something to keep in the back of your minds. It seems necessary. Our town's had zoning and subdivision regulations since 1972, and we've revised them a number of times. I very much like what I now call the 500-foot rule. Remember the old 800-foot rule? This is the 500-foot rule that you have, and it's, it recognizes the importance of our critical resource areas, especially the prime agricultural soils in the rural working lands areas. Very, very exciting to me. I call this tier 2 with teeth. I think it's well thought out. Anytime you put any kind of marker, like a distance, say, in this case, 500 feet from the road, you're going to run into issues probably and questions, and things might not be quite as smooth as they first appear. And I think, as I'm about to mention, if the towns are included in this process, it could be viable. I don't really like the 4-lot rule for subdivision. And the reason for that is, let's say I am a retired farmer. So let's say I have a nice 40 or 50 acre piece of land, and I need some money to retire with because, well, in fact, we did conserve our land and we're fine. But that being said, the point I'm trying to make is you could take your 40 acre piece and have 10 lots, 10 half-acre lots clustered off by the side of the woods and trigger Act 250. You would at 4, actually, right? On the other hand, you would not trigger Act 250 if you subdivided those lots into 10 lots of, say, 13.33 acres. That, to me, would be more impactful, because chances are that are going to be sold to folks who are going to plop a house down and take it out of farming altogether. So I think you should give some consideration to that. One way might be to rephrase it to look at in the rural working lands areas based upon the maps that if 5 acres or more were involved, then a jurisdictional opinion would have to be drafted and to examine the proposed project to see, you know, what kind of impacts it might have. Not dissimilar to what's done today with involved land and that kind of thing. So that's just a thought there. I mean, the key to much of this, and what I see as the quid pro quo between those of us who are concerned about our resource areas, is this planned growth area, which I also think is good, don't get me wrong. And so I think that exemption for the larger municipalities and those that are capable of meeting the requirements in the planned growth area designation structure that you're proposing is excellent. However, I do want to make you understand that towns aren't always right, and B&M Realty is an excellent example of that. That was Exit 1, where Scott Milne had proposed to have a rather large development. It was the planning, it met the local town plan requirements and approval with the town, but the regional plan, it violated that. We denied it. It went to E-Court. We were overturned. It went to the Supreme Court, and they upheld us essentially. So while they don't always get it right, I still think, you know, generally speaking, Hartford does an excellent job. One other caveat about exemption in these growth areas is something that I think you probably are aware of, but with exemption, there's always that carrot in Act 250 of, if you want to build priority housing projects, then you will be exempt from Act 250. Hartford's another example of that right now, where a 30-unit project was built along Sykes Avenue. And presently, Simpson Construction is proposing 250 units approximately, of which about 200 will be market rate studio apartments, and 50 of those other units will fall into PHPs, priority housing. So with that exemption, I think the law should have perhaps in this area plan growth that you have, would have something that would require the developer, if they were to get this exemption, also to have some kind of priority housing component. One of the worries I have with so many of these exemptions is that there's this loss of incentive. If it's so erroneous to go through Act 250, then and that carrot was helpful, and I think, you know, Gus Sela can speak to that, Evernorth can speak to that, Sally Byer, you know, some of these other folks that know more about it than I do. But I think you need to have something there to incentivize still affordable and working force housing. Now, not in your, I couldn't find it anywhere, but not in, and I also made a typo here, but I'm in favor of making permanent the jurisdictional threshold for permits for, you know, 25 units or some number there for downtowns, neighborhood development areas, village centers, and zoning bylaws is, you know, towns with subdivision and zoning bylaws. And it would be great if it was all of them, and growth centers, basically quoting the language that's presently been in S100 that was passed this past year. I think that, again, is this part of this balancing act between critical resource area protection, which is necessary to come through in this bill, tier 2 and tier 3, and this tier 1A and B, that as it gets called. I don't think it's necessary to call that, because this bill just magnificently goes through all this. The new requirements for RPCs are excellent and necessary, but I think that if this is to be successful, so much of this planning needs to be from the bottom up. It needs to come from local communities with the aid perhaps of the RPCs. This has been done with the energy committees before, to site where they want solar and wind. It's been done before when they, establish industrial, parks and zone. So I don't think would be hard to do this, and maybe there is language in the bill that I didn't see that, that would do that. I know our RPC works closely with the town of Thetford and helps direct us. Sometimes we get a little annoyed at them because they think they know more than we do. But and they probably do. They're planners, professional. And so finally, I just want to mention, it's just sort of a little thing I was thinking, that as climate change rages on, we need to strike this balance between building affordable housing, providing an equitable education, and preserving land to feed those who live in those homes and children that attend those schools. My story is that in the 80s, our farm, which is now 56 acres, would not have existed but for Act 250. And instead, maybe the housing crisis wouldn't be here in the town of Thetford, because we would have built an awful lot of houses. On the other hand, we would not have fed thousands of Upper Valley residents. We would not have given away thousands of pounds of food to willing hands and hired hundreds of school age, college age and high school age kids to work on the farm. So it's an interesting balance and tension that's always there. And then lastly, again, only related. I've mentioned this before, but with exemptions come a loss of fees. And I think Sabina has mentioned this before, and it's come up with testimony. But in our last years, and my last years as chair, we had 3 automobile dealerships move over. It was pretty exciting from over in New Hampshire, come over to Sykes Avenue. And then the Toyota dealership expanded, and we collected approximately $125,000 in application fees, $41,000 in transportation fees, which helped build these Sykes roundabouts that many of you may have gone around, and then $34,000 in offsite mitigation fees. And those are fees that go to the Housing Conservation Board, which can be used to secure other lands with conservation easements, either for farming or, in fact, to build affordable housing. These were minors, which means we got them out in 30 days or so, and they went very well. So that is primarily my testimony, and I just, one last thing. It's funny because I'm not a professional at this, and it really takes me a long time to get these things organized and together. I spend a lot of the time just trying to figure out what the heck the statute means and everything. That's Seth, well, I shouldn't say Seth and Amy here. I got to be more professional, I guess. That Chair Sheldon and Representative Bongart's pieced together. But when you finally settle it down and spend some more time with it, like probably a couple of days, it's really very, very good. So thank you.
Thank you for your testimony. We have a question from Representative Smith.
Thank you. Thank you, Tim. Thank you, Chair. I see that you've been on your DRB for about 20 years and you're chairing it now.
That's correct.
Do you think that your DRB could do as good a job faster than Act 250?
Oh, gosh, what a question. Well, since I've done both, our criteria are significantly different. We just had a situation where a zoning administrator, we had one leave and we were desperate for a warm body. We made a horrible choice, of which I'm 25% responsible for. And it was just a disaster for 2 years. And that person left, and now we have an excellent person. So, your foundation's your zoning administrator in some ways. And then I work closely with that person today and with the Planning Commission. So that is a question I've asked myself for years, because I think we've been in a unique situation here, being on the edge of Norwich, where all the builders want to build because they can build billion-dollar homes, and then being on the border with New Hampshire, where Lebanon seems to take the brunt of the housing, building the housing over there. And so we have not seen that much nor did I see that when I was chair of the Act 250 Commission. So we've never really been tested with our new zoning to see if we can do the job. We have good members on it, but we're still lay people. Of course, we're lay people as chairs, as members of the commission. But our criteria are different, as you know, in Act 250. Although, by and large, what we would be doing in a conditional use hearing and what we do with criteria 8 is deal with aesthetics. And, that's the citing and the mitigation and conditioning of a housing development or a commercial business. But no, I don't think we can do quite, remember, half the towns don't even have the zoning and subdivision regulations. I think we're a pretty talented group, but I think it could be difficult. I don't know if that quite answers your question, but I'm kind of agnostic. One example I'll give you years ago was a neighbor. It was going to be a really excellent small development near the interstate, perfect spot for it. But a neighbor and attorney, name will not be said, fought it, and eventually the applicants walked away. But that can happen in Act 250, as you know, too.
I have one more question for you.
Sure, yeah.
Can you describe a forest block? No one's been able to yet for me.
Well, that's what I would leave to the experts to show me what those forest blocks are. We're doing that same research using some of the same maps that have already been made. I get a sense that it is a fairly uninterrupted area of forest right now. But again, there's professionals out there that I would, when you're driving down the interstate coming back from Montpelier or Burlington, and you look out over these thousands and thousands of now pretty mature trees, and you go, wildlife, what are they worried about? I kind of smile, and I guess it's not the deer we're really worried about. I mean, the deer my wife woke up and watched 3 of them eating at our bird feeder this morning, I guess. And it's the predators, apparently, that we're really mostly concerned about with this forest block and fragmentation and that kind of thing. So I would have to, I can't define it exactly. I want to see what the maps are. Yes, exactly.
All right, thank you. I don't think anyone.
So they are mapped and they're on the A&R map atlas.
Yeah.
We can walk through that.
Okay.
Yeah.
Thank you very much.
Thank you for your testimony.
Oh, you're welcome. Thank you for having me. I appreciate it. And
we're glad you could join us despite the weather and any illness. So thank you.
Yeah, well, I'm much better. The good old amoxicillin. Thank goodness for that. And I wish you well trying to put this all together. And I do hope everyone who comes to the table, there seems to be some concept of working together, and I hope that happens. I've been told I'm very naive about that, but I hope it does happen.
Thanks
all
again.
Right. All righty, bye-bye.
Next up, we'll welcome Thomas Weiss.
Good morning, and thank you for shoehorning me into your schedule on short notice. I am Thomas Weiss, resident of Montpelier, civil engineer, and my experience with Act 250 goes back almost to the beginning, preparing land capability maps for the Ottaquechee Regional Planning and Development Commission in the summer of 1971. My most important comment this morning is that this bill needs to be implemented as a whole, all at the same time. This is particularly true of the 3 locations: the critical resource areas, the rural and working lands areas, and the planned growth areas. If you get Act 250 out of the downtowns first, the critical resource areas might lag behind many, many, many years and might never get developed. My second consideration is this bill balanced? The 3-tiered approach is intended to be a shifting of jurisdiction, reduced or no jurisdiction in the compact settlements, and more jurisdiction in the rural countryside to keep the countryside rural. And my comments are going to go more or less in order as they appeared in the H687. The purposes, they both seem narrow and unbefitting to Act 250. Instead, I suggest going back to Act 250, the original, and suggest using its declaration of intent. The legislature declares that in order to protect and conserve the lands and the environment of the state, and to ensure that these lands and environment are devoted to uses which are not detrimental to the public welfare and interests, the state shall, in the interest of public health, safety, and welfare, exercise its power by creating a state environmental board and district commissions, conferring upon them the power to regulate the use of the lands and to establish comprehensive state capability, development, and land use plans as hereinafter provided. My written testimony is on the internet site, so if you want to follow along there, I guess you can. If you just want to listen to me, that's fine too. The utility of the nominating committee is questionable. It will meet once a year to nominate one person, little continuity, little backlog of experience on members from year to year, because 4 of them are legislators, 2-year terms. I know many of you get reelected, but the quality of the board is also within the purview of the Senate Committee on Natural Resources and Energy in its advise and consent role. My limited observation is that the hearings in the Senate Committee lack substance and timeliness. So I suggest that you see if there's some way to improve that process. I'm a strong supporter of the supervisory authority of Act 250. That is why I know that Act 250 is neither redundant nor duplicative. That is why I support H687's proposal to add the longstanding court ruling that confirms Act 250's supervisory authority into statute. Act 250, right from the beginning, has been part of an intentional dual process. The legislator created many A&R municipal permits at the same time that it placed corresponding criteria into Act 250 and chose not to make them identical. This proposed section in H687 clarifies that it is indeed the responsibility and duty for district commissions and the board to apply their independent judgment in interpreting facts and interpreting law. And I find that the dual process is not duplicative because, as I said, the criteria for A&R and municipal permits are different than those from Act 250 intentional. Definitions, the proposed definition of fragmentation determines that some fragmentation is okay and other fragmentation is not. Under that definition, a new farmhouse will not fragment the forest block. A new residence that is not a farmhouse in the same location will fragment the forest block. The ownership or use of the house should not determine whether the forest or connecting habitat has been fragmented or not. And also,
How does the bill do that? Excuse me.
pardon?
How does the bill do that?
In its definition of fragmentation or forest blocks or connecting habitat.
It speaks to property ownership.
It speaks to uses. If it's one can put infrastructure for land, for farming and forestry and maybe one other purpose into a forest block, and fragmentation, and that doesn't count as it doesn't apply to the forest block criteria. So the residence is not allowed, or has to be considered in the forest block, and the farmhouse does not have to be considered. And the criteria for forest blocks and connecting habitat refer to mitigation according to a section 6094. And I hesitate to ask, what is section 6094? I've not been able to find it. And I don't see how avoid, minimize, mitigate works for connecting habitat. Connecting habitat is fundamentally different from forest blocks or primary agricultural soils, which also propose or allow avoid, minimize, mitigate. The difference is that if the project severs or has an adverse impact on connecting habitat, there is no alternative for the species using that connecting habitat. And there's something wrong in my mind with having the outgoing NRB create the rules for forest blocks and connecting habitat. The outgoing NRB could have shown some initiative and made such rules years ago under their rulemaking authority as part of criteria for criteria 8 or 9C. And there's no reason to use rulemaking for these new two criteria. The Commission on the Future of Act 250 provided specifics in its draft bill, Appendix 4 of the Commission's report, and that is a reasonable start and would need some revision in order to update it from 5 years ago. But I think it would be a good start to avoid the long rulemaking process. And I support the proposed definitions of development and have some enhancements. Act 250 has mostly been concerned with commercial, industrial, residential uses, and several of the proposed definitions, I believe, would be enhanced by adding governmental purposes to them. I am surprised and disappointed at how few critical resources have been listed. I request additional ones, connecting habitat, headwaters, fluvial erosion areas, the highest qualities of groundwaters, and the highest qualities of surface waters. And I request that the definition be expanded to clarify that when a critical resource occurs within the boundaries of a planned growth area, that the critical resource area is carved out of the planned growth area and is subject to the rules of the critical resource areas and not the rules of the planned growth areas. There are 3 different versions. The thorniest issue is, how does one get Act 250 out of the compact settlements and out of which ones? I believe that H687 does not answer that question. For a long period last year, the NRB report planned to defer to ACDA, Agency of Commerce and Community Development, on that question, and the agency planned to defer to the board. The agency's resolution appears to be that everyone who can have a designation and only some will be eligible for unspecified Act 250 benefits. I've not made time to listen to your hearing on the designations, so I'm not sure if that is still current or not, but I believe it is. There are 3 different versions of delegation of Act 250 authority in the various bills that have been presented and that are floating around this committee, mostly up there. My concept of getting Act 250 out of downtowns has been that the Act 250 criteria would not be ignored, rather the criteria would still be considered. None of the 3 different versions describes the conditions needed on the ground to be eligible for a designation. They list documents needed with no specifics on the contents of the documents. And I think you really need to spend a lot of time on the content of those documents, particularly as they relate to the Act 250 criteria. Based on my experience with the report submitted on necessary updates to Act 250, I have little faith that the NRB, in its present state, can produce an adequate process. The NRB was given 7 charges for that report. My comments in volume 2 of the report point out that the report failed to respond to most of the charges. And the minutes of the meetings showed that the board itself took no part in the development, review, or approval of the report. And the NRB doesn't even take ownership of the report being issued under the name of the company hired as a facilitator. I request that you work out the specifics of the contents of the documents as they relate to the Act 250 criteria, particularly in the bylaws and the municipal and regional plans. And I request that you not consider the delegation proposal contained in H719. It leaves too much to be determined later. Release of land for permits has 2 different takes. I have concerns with both processes for handling Act 250 permits and the designations. Having been a consultant and witness to a party in an Act 250 case, I am concerned that this section is not set up to support a party and give the party a right to learn of and retain the conditions. And I request that you work out resolutions to prevent the hard-earned conditions of parties from being discarded without the consent of the parties that obtained those conditions. H719 proposes to require no mitigation of primary agricultural soils when used for subsurface water and subsurface wastewater treatment systems within a designated area. H 687 proposes to include primary agricultural resources as a critical resource. Thus, the primary agricultural soils cannot exist within a designated area. And on the other hand, put a large subdivision using alternative wastewater systems on primary agricultural soils, and poof, no more farmland and no mitigation. And I have a fundamental difference of opinion on appeals than does H 719. My experience with appeals is that they are a useful and necessary part of permitting. There are several limits to permitting to appeals provided in H 719. I don't know what an injury in fact is, given the other portions of H 719 that propose to limit the ability to appeal. I have a feeling that this is intended to limit the ability to appeal. The section also proposes to require one who appeals to provide a bond. The amount of the bond would be decided by the court based on vague factors. I, too, have been unable to find information on the judiciary's internet site and have been unable to determine the outcomes of appeals. I believe it was Representative Boss who presented testimony on that in her bill 2 days ago. And without that information, one cannot judge whether appeals are being abused or not. H 719 proposes to raise the number of persons who are required in order to appeal decisions of the administrative officer. Decisions of an administrative officer are rarely required to receive public notice, so the individual who was most likely to learn of a decision is the one the decision involves. That individual should not be stymied in the ability to appeal by increasing the number of individuals needed to appeal to so high a number as proposed in 719. The section also prohibits appeals on decisions on housing projects, which also prohibits the developer from appealing an adverse decision. It works both ways. H 652 proposes to extend the exemptions in Section 16A of Act 47. I opposed those exemptions last year, and I still do. H 760 proposes to require the Act 250 database to include documents relating to the Environmental Division. That's the bill I was talking about a few moments ago. I support the request, as I too have had similar experiences. I also request that you direct the Natural Resources Board to allow one to search for appeals on the Act 250 database and to provide the court case numbers of the appeals. That was one of the hardest things I found was trying to correlate Act 250 case numbers or permit numbers with court case numbers. They don't relate. The court doesn't rarely mention it. Might mention it in the title of what it's got on its list when you search for Act 250 municipal cases. But I couldn't get into I couldn't get to find the appeals itself, find the decisions, find documents. In summary, H 687 does strive to strike the balance sought by the Commission on the future of Act 250, reducing some jurisdiction in the compact settlements and increasing jurisdiction in the surrounding countryside. The unbalanced approach of only reducing jurisdiction in the compact settlements will do little to relieve the pressure on development within the rural countryside. And H 687 has features that will perhaps not relieve these pressures, but direct them to areas more suitable to our ultimate need for sustainability. H 687 is encouraging moving many more people and much more activity into the compact settlements along the rivers, and that is counterbalanced by including river corridors as critical resources and carving them out of the designated, the planned growth areas. Making all development within a river corridor under the jurisdiction of Act 250. That's an important benefit to making our population less vulnerable to the sizes of floods that we have seen this year and the larger floods that we know are coming. I remind you that I consider the balance must be implemented at one time. Plant growth areas, rural and working lands, and critical resource areas all together. My written comments have a few more things in them, and they do provide suggestions or requests for each of the topics that I've talked about. And thank you for listening to my testimony. I hope that you find it and my written comments of use in your deliberations on this bill and the other bills proposing to amend Act 250, and that you incorporate many of these suggestions and requests into Act into Bill H 687. That ends my testimony. Thank you.
Thank you. Thank you for that thorough review of the bill and for the many suggestions. You gave us a lot to think about. I was following along, trying to follow along. So I appreciate that you submitted it in writing and also gave us an overview in your oral testimony. Do members have questions right now? I suspect there may be some more after this too. Representative Stebbins.
Thanks, Madam Chair. Good morning, Mr. Weiss. Wondering, we've heard a proposal that people like having the appeals and the option to go via the court, and we've heard people say they like having it in future, assuming we have an ERB before the ERB or now current NRB. I wonder what your thoughts are on that.
That's really outside my area of expertise. I've heard the arguments both ways, or the discussions both ways, arguments in the sense of debate arguments rather than people yelling at each other. But I have no conclusion. It's my understanding that when the Environmental Board heard the appeals, it was more productive for Act 250 because the current Natural Resources Board, or none of the Natural Resources Boards, as far as I know, has taken it upon themselves to review the outcomes of the appeals and to determine whether or not to modify the rules or to request statute changes because they were uncomfortable with the outcomes of the appeals. So I tend to be leaning towards returning appeals to an Environmental Resources Board with the capability to handle that. The Environmental Resources Board will also have the responsibility to handle all of these designations under the proposal submitted in H 687. I believe other bills might be suggesting that the the regional planning commissions might have that responsibility. But I'm leaning towards Environmental Resources Board, but if there's a lot of evidence in the other direction, I might be persuaded to change my mind. I'm an engineer of scientific method. Gather data, make decisions. If you find more data that contradict what you decided on, it's okay to change your mind.
Amen.
Other questions? I'm not seeing any right now. Thank you again for your testimony.
Very welcome.
All right, members, let's take a 7-minute break. Come back at 20 minutes past the hour and we'll have our legislative council here for walkthrough.